Today we're going to be talking about limitation of liability clauses. This is a key clause in your contract to provide a risk allocation. Some of the points I want to make is you should limit your liability through this clause. It protects you against client claims. It does not protect you against third-party claims. Include this in your standard terms and conditions. If you're dealing with a client-created contract, they generally are not going to have this clause, so you should be routinely adding the clause to those contracts by your clients. Make the clause applicable not only to the firm, but also to your employees, all the individuals, because there are court cases that have held that an limitation of liability clause that limits liability between the corporation and the client does not limit the liability that that client might be able to go against an individual engineer for. Define what causes of action this clause is going to apply to. It needs to say that it applies to breaches of contract, negligence, strict liability, warranties. There are courts that have held that if you only say it's applicable to negligence causes of action, they won't apply it to a breach of contract. So make that clear. I often see these clauses say it applies to all causes of action. Not good enough. Define what those causes are. Establish a reasonable dollar value to that limitation. Say it applies to your liability for all these causes of action, and the limit will be your fee or a dollar amount, whichever is greater. So a lot of times I'll be dealing with somebody who's got a small fee, $5,000. We'll limit our liability to $25,000 or that fee, whichever is greater. That makes it very enforceable. The point is you want to have skin in the game because courts often look at this and say that it cannot be an exculpatory clause. If this clause completely eliminates all liability for the firm, most courts will say that it violates state law. So you need to have skin in the game. If you have a client that pushes back and says, we don't want to limit to a dollar amount, we want to limit it to your insurance. Be careful with that. I often see it say, we limit the liability to the insurance proceeds available. Not good. You might have a $5 million policy and your contract only required you to have a $1 million policy. Why give up your whole $5 million? So what I like to do is say that it will be the amount of insurance proceeds available up to the minimum amount specified by the agreement for the primary insurance policies. That way, you're only giving away the amount of coverage the client asks for and only for your primary policies. There are other things to think about. Add a clause that will bar limitation of liability. It'll apply this limitation of liability to specific individuals. It will say that no director, officer, shareholder, or employee will have any individual liability, and you can make that mutual. There are courts, again, that will sometimes say that you must actually use specific statutory language. I'll give you one example. Florida says you have to use the exact wording of the Florida statute. It has to be all capital letters, and it has to be 5 font sizes bigger than the rest of the contract. So be sure you know the state law. One point I want to make on all of this, we're talking in generalities. Everything I'm saying here today, you should speak to an attorney in your state to be sure that you are complying with your state law and the common law of the courts in your state to make an enforceable limitation of liability clause. One other thing I'd like to leave you with is a waiver of consequential damages clause. This is different. It is separate from the limitation of liability, but it is a vital clause. It's standard in the AIA B101, and I recommend that you always include this. What it says is both parties waive those economic, consequential, indirect costs against each other. But what does consequential mean? Courts might be all over the fence, all over the place on what that means. I like to define it to say that it applies to lost profit, revenue, business opportunity, lost use. All those are great things to put in your clause that will make it enforceable so you avoid those types of damages. I have in the slides today a limitation of liability clause that you can look at and see each of the points that I made and study that and see how what we're talking about applies to that clause. I also have a mutual waiver of consequential damages clause. Again, I commend you to read and study that clause. If you'll use those clauses, you will be way ahead in protecting the assets of your firm. Thank you very much.